Yes.
Yes.
Over the objections of the lender?
Yes.
Yes.
And can it be done on residential property?
No. Except
Yes.
here.
Yes, it can.
Okay. Judge's gonna explain it.
But just on the interest rate in commercial setting, Supreme Court came down with a case called Till, and it actually was in a residential setting, but it applies in commercial settings, and it talked about the proper interest rate when a loan is crammed down as part of a plan, meaning restructured in any sense. What is the interest rate? Because the secured creditor is entitled to be paid over time, the time value of money, but at what rate? And there were arguments. It should be the contract rate. It should be the default rate. It should be the market rate. It should be the rate the lender could get if lending money at that time. And the Supreme Court said that was all too complicated. We can't have judges who aren't too bright have to figure all that out. We're going to have a formula. It's called the Till formula because the name of the case. You're going to have prime plus an upward adjustment based on risk of 1, 2, or 3 points. And there are experts now in this country who will come testify as to the appropriate application of the interest rate, Till, and how to apply that rate. But it's not a huge gap. When you deal with prime, which is virtually, 2 or 3%, plus 1, 2, or 3 points. That's the rate that's supposed to protect the lender from the risk of a default under a plan.
There are a lot of experts now testifying on the Till rate, and some of your testimony, some of your reports is often used in connection with figuring out Till, because the upward adjustment is based upon the risk, and some of that goes to the value of the collateral. So I've seen a lot of appraisals and appraisers provide some testimony that's accepted by the court in figuring out what the Till rate should be.
Now, maybe we'll wind up just answering the question on residential, stripping off mortgages and playing with interest rates. The bankruptcy code provides that you cannot modify, because the mortgage industry, the banking industry was so powerful, their lobby was so powerful that they convinced Congress to put in provision that said you can't modify a home, basically a residential mortgage, to bring it down to its simplest terms. All right, a loan secured by a residential property. The debtor cannot modify it, can't extend it, can't change the interest rate, can't strip it off. Courts have said, okay, we're stuck with it, that's the law. But there are situations where that loan, that lien, is not secured any longer by real estate because there's no value. Look in this setting. The property's worth $450, the first mortgage is $525. Okay, after the first mortgage, there's no equity supporting the second mortgage. So courts have allowed parties to strip off, the debtor to just take that second mortgage and strip it off and pay that $75,000 as if it's an unsecured claim at 10 cents, 5 cents, 1 cent on the dollar. They've also allowed the ability to modify, if they want to keep it on, maybe reduce the interest rate. It could be played with. So there is a scenario. What I talked about is I think there should be the ability to cram down even the first. Why should they have to pay $525 on a property that's worth $450? They can't. They can't make it work. Maybe they should just have to pay $450. Now it can become a performing loan. It's something reasonable. It won't be abandoned. It won't be foreclosed. And the neighbors will be happy and everybody else, but Congress doesn't agree. I won't go there.
There was a bill that was denied, right?
That was denied.
Now, it's important, though, like, under your scenario, Judge, if the first mortgage was $445,000, what could you do with the second mortgage?
Nothing. As long as there's at least $1 of value, doesn't mean have to be fully secure, but as long as there's at least $1, I can't modify it. It's a fiction. But we're saying if there's no value supporting that loan, it's not a secured claim. So you can play with it. It's really just an unsecured claim. But if there's at least $1, it's considered secured.
So as a homeowner, if I own a house and it's not worth what my mortgage is and my second, I can do this?
If you're a homeowner, it makes so much sense for you to default on the first, stop paying, let the interest and everything build, so you use up any equity there would be, so that you could then strip off the second. You know, there's a lot of games you could play.
Well, and so what's that do to my credit? Is it just,
Oh, your credit's done.
Oh, your
destroy
credit
it?
shot. But if you're filing a bank, what's more important, your credit or your home?
Hey,
If
exactly.
you're filing a bankruptcy,
exactly.
it's on your credit anyway for the next 10 years.
exactly.
Under this scenario, your credit, to save your credit, would be worth $75,000.
It's
So-
adjustable.
And you're not homeless.
But
which is
listen,
more-
in this economy, we know with the drop in home prices and what loans were given, those second and third mortgages can be in the hundreds of thousands of dollars.
10 minutes. 10 minutes.
Oh,
There's
go
a
10 more.
question, right? Yep. All right, we gotta
I
get on
know.
tape.
I was getting ready for tea time.
How many times can a residential homeowner claim bankruptcy?
As often as they can afford the lawyer.
You can get a bankruptcy discharge once every, was it 7 years?
7 or 8.
7 or 8?
It's 8 years to get a discharge under Chapter 7, but you can file a bankruptcy repeatedly as serial filers in a Chapter 13. Yeah, many of the filers have filed 3 or 4 times. You might not be able to get a discharge. Technically, you can't get a discharge in multiple Chapter 13s more than once every 2 years if you're a 13. If your prior case was a 7, it could be 4 years. But what happens are the debtors aren't completing their plans. They file a Chapter 13 to stop the foreclosure. They come up with a plan that'll pay their arrears over 36 to 60 months. They get into about 18 months and they can't afford the plan. So they dismiss the case. The lender goes back, schedules the foreclosure sale 9 months later. They file again. They go through the process for another year or 2, dismiss the case. Lender goes back, starts the That's how that woman was there for 6 years.
It used to be common that some
I
debtors.
seem so jaded.
Yeah, really.
Some debtors would file what they'd call Chapter 20s, which would be a Chapter 7 to discharge debt, followed by a Chapter 13 to restructure mortgage debt. Are you still seeing?
We see lots of Chapter 20s. I think when I was practicing my record, I was up to Chapter 33.
But there's now, the reason this is getting less and less common, there's now a provision under 362 that when relief from the stay is granted, it can say even if you file again, it will not stay a foreclosure if the file's within 1 year, right, Judge?
Right, those are in rem orders. What we're saying is, all right, this debtor has abused the process so often that there's no palpable, reasonable reorganization, that I'm granting stay relief to the lender and it applies to the property. Because I don't care who owns it, because we see the debtors, if they can't file again, they deed the property over to mom and sis and son, and they file the bankruptcy. So it doesn't matter who's filing the bankruptcy.
But it's within 1 year, right? It's 1 year that inability to get the stay applies.
Right.
And that's what's amazing about that is when the judge started off the program and he said it's taken 900 days, that's 3 years, obviously, almost 3 years, then the 1 year is not enough to get the lender to the title of the property. So it's just, again, it's uncommon. It's less common now than when the three of us started doing this to have these serial, but it happens, especially with individuals.
Oh, last week I had a debtor, I won't name, obviously. She's filed 12 bankruptcies since 1994. I've only been on the bench 6 years, and I've had 5 of them.
Wow.
And she came in front of me. And unfortunately, it's because she was doing it without an attorney, and cases kept getting dismissed, and she couldn't make it work. I had barred her from filing for 2 years. The day after I entered the order barring her from filing, she filed again. Because the clerk has to accept anything that's filed. There's no choice. She finally came in front of me. We realized what her problem was.
What was it?
I gave her a week to find an attorney. Because at the end of the day, she couldn't do it on her own. So, I mean, there are avenues of abuse, but there are people who really need the help, and the abuse is just unfortunate.
I just want to, since we're in our waning moments here and we're sitting between you and lunch, and that's not a good place to be, I just want to tell you how much respect that I think the judges and lawyers in the system have for the work you do, and that's why, in part, why we are really careful to get you paid, because you add value in every case. You add value in terms of us not committing malpractice. You certainly add value in terms of judges
Absolutely.
who are throwing darts up against the wall all the time in having a basis for their decision. They're supposed to use notions of fairness and common sense, but we do have tremendous respect for the work you do, especially when you do it, you know, as you all do. I note that in the materials you were given at page 38, there's actually a decision by one of Judge Kaplan's colleagues in Trenton, where your esteemed, I think you're still president, President Chuck Blau testified at length in a case called Curtis Paper at page 38, where the judge goes on at length to talk about how he was named Appraiser of the Year for 2003 and 2004 by the National Association of Independent Fee Appraisers. So again, it matters, the work you do in this association and the work you do for the courts and for the lawyers. So we have tremendous respect for you. I also do want to take a moment to thank my colleague, John Stokler, who put together the materials with the judge and Dan giving it to him. So thank you very much for your effort, and thank you.